Hey out there, legal warriors. In this video, I'm going to cover the 3 most common critical thinking errors that land people in jail who have a no contact order against them. It may not be you right now, let's hope it never is, but this is a very important area of the law where people make mistakes that have huge consequences for their life. So if you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington state for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now I'm just going to jump right into it. What are you talking about, Lance? Well, I'm talking about somebody who is restrained typically by a criminal no contact order. A criminal no contact order means that a judge has issued a no contact order as a condition of someone being charged with a crime. Usually that would be a domestic violence crime. It could be a regular assault crime. It could be a violation of other no contact orders. There's lots of reasons, but in this case, we're talking about someone who has a no contact order against them. It would also count for a protection order against somebody, but typically there's different factors involved about the common mistakes I might see in protection orders. So what are the 3 critical mistakes or thinking errors that people make? Well, number 1 is people often think that if the person who's protected, the alleged victim, invites violation of the order, then it says, hey, come on over, hey, talk to me, Mr. Restrained person, then that's not a violation of the law because, hey, they asked me to talk to them. If you're caught with that other person, even if they invited you over, even if they came to your house and you just let them hang out, even if you picked up the phone and said, talk to them even though they called you, that's called a permissive violation is what we call it, is a sort of a slang term in the legal practice, but that's not a defense. Any violation of the order, even if invited by the protected party, is a crime. And of course, a violation of no contact order for the most part is a gross misdemeanor, maximum penalty of a $5,000 fine and 364 days in jail. And in some instances, it can be a felony, which is much worse. So often I hear, well, Lance, she's calling me and all I did was answer the phone and talk to her. Or she walked up to me in court and started talking to me, so I talked back. Or, she doesn't want the order. It was a birthday party and I wanted to go see my kid, so I went to the birthday party. Well, all those types of cases have actually turned into criminal charges against people in the real world who've gone through those real world situations. So I don't want you to make that thinking error that a permissive violation is not a violation. It is. Now, we might use the fact that this person invited the violation to help mitigate the circumstances, but you're still getting arrested, you're still getting put in jail, you still have huge criminal jeopardy. So even if the protected party is inviting you to violate the order, don't violate the order. And secondarily, a caveat to that is don't trust the protected party if they're saying, hey, the order got recalled or I got the order dropped. I can't tell you how many times I've seen the protected party lie to the restrained person because they want to see the restrained person and say that the order was dropped, and the next thing you know, the restrained person's getting arrested because it wasn't dropped. It's not a defense that he or she said it was dropped. You've got to figure that out on your own. You better have that order in your hand that cancels the original order before you feel it's safe to go ahead and resume contact from the person who you were restrained from in the past. So mistake number 2, critical thinking mistake, is thinking that, hey, there's no way I'm going to get caught if there is a violation, if it's permissive. And I'm going to say mistake number 2 I often see in 2 places. Number 1 is crossing the border, right? We live on the border with Canada, and there have been a high number of cases reaching out to my office in the recent past where someone has been caught crossing the border with the protected party. Obviously, these people are traveling together, and the protected party doesn't care about the order. But when you cross a border, the international people are going to check and see if there's a no contact or a protection order against you. That's what they do. That's part of their job. And if there is, you're getting arrested, right? And you don't want that. That also applies to an international flight. International flights, they're always going to check at the border, at least when you're coming back to the United States. They don't necessarily check when you're leaving, and it's not legal advice. They could, but I haven't seen that happen. So that is an area where it's 100% chance that you're getting arrested. The other area is if somebody is driving in the same car with the protected party as a passenger or whatnot. If anytime law enforcement checks on one of you, your name is going to pop up as either restricted or protected. And you're driving in the same car, there's a traffic ticket, you get rear-ended, something you would never expect police involvement, and now police are involved, they check the names, and the restrained person is going to jail. So the thinking there is thinking, hey, it's not going to get checked, there's no way it can be found out, who's going to know? That's not how it happens. And I think the third thinking error that I see all the time that can lead to eventual jail, because the order going on forever, is, hey, there's nothing I can do about it. There's no way to get it changed. And people feel helpless at times, and they think there is no way to get something changed, but that's not the case. If you've watched some other videos here, you know that you can do things to help improve your position when it comes to having the court remove an order. And for a criminal case, the alleged victim may come in and ask to have the order removed, and oftentimes the court says no. The court may, though, ask the defendant, the restrained person, hey, what have you done that puts you in a different position today than when I first entered this order? And if you've done some classes, some domestic violence classes, some anger management, maybe it's alcohol stuff, hopefully you're working with your attorney to figure out what's necessary. But if you've done that, that'll put you in a better position to have that order removed. Don't make the mistake of thinking that if the victim wants to maintain the order that you can get it removed over the victim's objection, because the court's almost never going to do that. But we're talking about oftentimes the protected party doesn't want the protection and the court's doing it on their own. So if you as the defendant have done some stuff to help improve your position, the court's more likely to be able to listen to what the protected party, the alleged victim, wants. So those are three critical mistakes that so many people make that land them in a jail cell. Well, if you found this useful, please like and please subscribe. More people get to see it, more people get the help they need. And more importantly, if you have a criminal matter in Washington State, feel free to reach out to my firm, either as a defendant or an alleged victim. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.